sort of thing. I was fine either way. He suggested I go second. I said, you prefer to go second, so that's fine.
All right. I think we're set.
The Medieval Academy Fellows.
Yeah. Yeah, we're laughing because there's an agenda for the medieval Academy, which is also taking place here in the Hyatt. Years ago. Well, thank you. Thank you for reconvening with us. My name is Matt Jennejohn. I'm one of the faculty members at BYU Law School, and I'll be moderating today's panel. Let me just do quick introductions, and then we'll get on to everyone's thoughts. So to my left is Marina Ohlhausen, who chairs Baker Bott's Global Antitrust and Competition Practice. She, prior to Baker Bott, she was a commissioner at the FTC and acting chairperson, where she directed all aspects of the FTC's antitrust work. I should also say, I learned last night that she was also, I think, Aaron Nielsen's first boss.
That's
when
right.
He was a 1L law. So now we know who to thank.
I'm very proud of that. So he worked for me in OPP, actually.
Oh, look at that. There we are. And then to Maureen's left, we have Dick Pierce, who is at George Washington Law School. And has authored over 20 books and 130 articles on administrative law, government regulation, and the effects of various forms of government intervention. That is astonishing to someone who's a little bit newer to the academy and raises a very high bar for my own productivity. And then we have Marina Lau, who is the Edward Hendrickson Professor of Law at Seton Hall Law School, and she was the director of the Office of Policy and Planning at the FTC from 2015 to 2016. And finally, we have Nikhil Shanbhag. Did I pronounce that right, Nikhil?
Perfect.
Who is the Director and Associate General Counsel for Competition and Regulatory Law at Meta, previously known as Facebook. Prior to that, he was General Counsel at Instacart and the Director of Global Antitrust and Competition at Google. So we have an astonishingly just experienced and delightful panel with us. We're going to lead with Maureen's comments, and we'll go down the line, and we'll have some interaction with everybody on the panel, but we'll then open this up like our previous sessions to questions from the audience. So please put your thinking caps on and be ready with some questions for our panel.
Great. Well, thanks. Thank you for having me, and Aaron, lovely to see you again, and really delighted to be here to talk on what I think is a really fascinating topic at a very interesting time for the Federal Trade Commission. I know the previous panel, I believe, addressed a lot of the consumer protection rulemaking and what led to the enactment of the Magnuson-Moss rule. So I'm going to focus my remarks mainly on the FTC's efforts to do an unfair methods of competition rulemaking. So the FTC has two basic sources of authority. It's unfair methods of competition authority, which is generally Antitrust authority, and it's unfair and deceptive acts or practices authority. So I'm really talking about more the UMC authority. And to the basis of that as a basis for rulemaking. So the FTC is generally tasked, or was generally tasked, with doing case-by-case enforcement in the antitrust unfair methods of competition area of its authority. And that is how it's proceeded for many, many years, bringing cases, sometimes in federal court, sometimes through its administrative litigation process, which then eventually goes to federal court and frequently up to the Supreme Court. So this current leadership at the FTC has an interest and has now taken action to try to enact rules using its unfair method of competition authority, so not case-by-case enforcement. And it bases the argument that it has this authority going back to that 1973 case, the petroleum refiners case, where the D.C. Circuit considered whether the FTC had authority to do any rulemaking using this part of the FTC Act called 6G, which is not part of the statute that really talks about the case-by-case enforcement, but is more in the other part of the statute about the other FTC tools like policy studies and administrative litigation and things like that. So when the court considered this combined FTC rule, so the FTC was trying to promulgate a rule to require that octane ratings be put on gas pumps, and the FTC argued this was both an unfair methods of competition and an unfair and deceptive acts or practice together. So the court ruled that the FTC had rulemaking authority, citing back to this 6G. Now, this is just a D.C. Circuit opinion, right? It's not a Supreme Court opinion. In response to that, Congress considered whether the FTC had authority, and it promulgated the Magnuson-Moss Act, which gave the FTC rulemaking authority for unfair and deceptive acts or practices, and put in a host of special guidelines and requirements and guardrails for the FTC to do this. So it wasn't notice and comment, kind of streamlined APA rulemaking. Then the FTC started to do a lot of rulemaking using this authority, and I think Howard Beals probably talked about that and the history of that in the previous one. It didn't try to promulgate an unfair method of competition rule until this year, right? So we go back from 1973 till, the non-compete rule making that just came out in January. The current leadership believes that because the Magnuson-Moss Act didn't take away the FTC's unfair method of competition rulemaking and actually said I'm trying to remember the exact phrasing. It was something like it doesn't affect any UMC rulemaking authority the FTC may have. And so kind of putting those things together, the current leadership says, oh, well, this UMC authority survived from that petroleum refiners case to today, and now they're trying to implement it. Interestingly, I looked and I said, well, whatever happened to that particular rule, right? That was the rule at issue before this petroleum rule, the octane rule. And what happened was Congress actually enacted it as a statute, and despite the FTC's request to get UMC rulemaking authority, said it is an unfair and deceptive act or practice, and you can have rulemaking, but with a few extra guardrails put in there. So to my mind, that suggests that it's very thin reed to argue that UMC authority has survived, rulemaking authority survived through all that. But in particular, statutory interpretation has really changed since 1973. So when we look at recent Supreme Court case law, like I would point to particularly the FTC's case involving AMG, where the FTC claimed that the fact that it had the authority to get injunctions meant it actually had authority to get all equitable relief, including monetary redress. And the FTC had used that quite effectively and aggressively to get a lot of money, and it had several circuit courts that agreed that it had that authority. Well, when it went up before the Supreme Court, the court looked at the FTC, the language, and it looked at how that fit into the FTC's wider statute, and unanimously said the FTC did not have the authority to get money redress. So, this is not sort of the, only the Republican Trump appointees on the Supreme Court. This was a 9-0 decision. There's certainly a lot of other questions. There was a big discussion in the Gundy case and other cases about if an agency hasn't asserted authority for a long time, that is evidence that it probably doesn't have that authority. But today we have the FTC asserting that it can promulgate a rule using its unfair methods of competition authority based on this kind of thin reed of 6G. We also have a Supreme Court doctrine that says Congress doesn't hide large grants of power in mouse holes. It doesn't hide elephants in mouse holes. And 6G seems kind of like a mouse hole, I think. So the FTC, though, now has taken this and issued or put forth for public comment a very broad rule to prohibit non-compete agreements, almost on a per se basis. It says it will preempt all the state laws on non-competes unless the state laws had even more restrictions than the FTC rule would have. So I think that's a very good example of how, taking this kind of authority to now go in and say, we're going to, as an unfair method of competition, prohibit an act or practice that states have ruled on and that has been weighed based on sort of the rule of reason and take a more per se approach, I think really illustrates why this is such an important issue. It's not just some sort of dusty admin law kind of thing. If the FTC is given this broad authority, it can really try to use it to get around antitrust case law that it doesn't care for, and that it can be used to sort of really, really change the direction of competition law. One other point that I wanted to make about the grant of rulemaking authority that the FTC is claiming in 6G, unlike Mag Moss, where the FTC was given the authority through Congress that a violation of a rule, they can get a fine for that. There's no provision in the FTC Act for what is the punishment for violating a UMC rule. So that's just another sort of weight on the scale of, does the FTC, has it really clearly been given this authority? And the court today, when you look at like the West Virginia versus EPA case, is asking that question very, very, I think, strongly to say, is the agency asserting a power that Congress has given it? I think there's a strong question that it doesn't have this UMC rulemaking power, and then an even stronger question under the major questions doctrine, whether it can use that power to then put out such a broad rule that's been this, affects the whole economy and has been the subject of a lot of state laws. So I'll stop there.
Yeah, thanks, Marina.
Well, I agree with Maureen and with Tom Merrill in terms of the skepticism that they express about whether the FTC has the power to use notice and comment rulemaking to define some practice as an unfair method of competition. And I share the skepticism of both Howard and Jeff as to whether the what Jeff calls the mossified procedures are a practical way to go that's likely to do much. Chair Khan is a young person, but she wouldn't be young by the time one of those cases finished. But I want to segue a bit and shift completely to another topic in a sense. All of the discussion so far has been about the power to issue substantive rules and the procedures an agency has to use to issue substantive rules. Substantive rules are legally binding rules. That's a terribly important question. What I want to do is talk about interpretative rules and statements of general policy. Those are types of rules that the FTC clearly has the power to issue and has for many, many decades issued many interpretative rules and statements of general policy. They call them guidelines, but it doesn't matter what an agency calls them. They are, as a legal matter under the Administrative Procedure Act, they're some combination of interpretative rules and statements of general policy. They are extremely valuable in the context of the Sherman Act and the Clayton Act. Those are both very broadly worded statutes that can be interpreted in a very wide range of ways. So it's terribly important that everybody, the general public and firms that are particularly potentially affected by antitrust law, has some way of knowing with a bit more particularity what the enforcement agencies think the statutes mean and the policies that the enforcement agencies are pursuing with their applications of the statutes. And the FTC, almost always in conjunction with the Department of Justice, issues these guidelines, and they've been very, very valuable and continue to be valuable in many contexts. They are particularly valuable in the context of mergers and acquisitions. Section 7 of the Clayton Act is extremely broadly worded and susceptible to a lot of different potential interpretations. The Supreme Court has not addressed any any case under Section 7 for 50 years, and its handful of opinions before that are highly suspect because we know that the Supreme Court has changed dramatically the way it thinks about all antitrust issues since then. So there's no judicial guidance out there that's very useful. So the guidelines that the FTC and the DOJ have been issuing are extraordinarily valuable. They allow both the general public and firms that are contemplating a potential merger or acquisition to sit down and look at these very detailed guidelines and say, okay, the transaction I have in mind either is certain to elicit, or virtually certain to elicit a yes, that they're not going to, neither agency will object because it has these characteristics and the way they fit with, or, oh dear, it's certainly going to elicit a no, and so unless I want to do litigation with the government, I backing off, or it falls in a relatively small category of cases where it's just not clear. But they also tell you exactly what kind of data and what kind of analysis you have to submit in a Hart-Scott-Rodino Act proceeding. Now, Hart-Scott-Rodino Act created a brand new system of agency adjudication, but it's completely different from any system of agency adjudication that has ever existed before or exists to now in any context. All other agency systems of adjudication involve very transparent processes that are very similar to court proceedings. So it's very easy to figure out what the agency is arguing, what kind of evidence you have to present on the other side. The agency's reasoning is always transparent. But the Hart-Scott-Rodino process is not like that. It is the most opaque process we've got by far. Everything happens behind closed doors. The public knows nothing about what happens except in the very rare case where DOJ or FTC say no, and the party decides to go forward anyway, and then you discover during the course of the court litigation what the case was all about. So that means that these guidelines are really the only source of guidance about that can permit a firm to say, oh, this is likely to go through, this one's likely to elicit a no, this one's shaky. And the only source of information that a firm contemplating a transaction of that type can use to try and figure out what data do I need to submit to the agency, what kind of analyses do I have to submit to the agency as part of this Hart-Scott-Rodino process. That produces a bit of a problem because what's absolutely clear is that Chair Khan in particular disagrees with everything that the FTC has ever done in this Section 7 area. I mean, that's not an overstatement. If you read her writings, if you read her speeches, you listen to her speech, she's quite clear. She thinks everything they've done is wrong, okay? And she wants to take a completely different approach. So it's quite clear that the guidelines that were issued, say the horizontal guidelines that were issued in 2010 and now have been withdrawn, that they are totally irrelevant to the Hart-Scott-Rodino process. And that creates a situation where any firm contemplating entering into any kind of merger or acquisition has absolutely no source of guidance. I would commend to all of you, if you haven't already, what will be, I'm sure, a law review article that Dan Sokol at USC has posted on the Social Science Research Network. What he did was he studied, he interviewed, he and a team of others interviewed all of the lawyers and economists who have been heavily involved in helping firms that are contemplating a merger and acquisition figure out what they need to do to satisfy FTC or DOJ and predict the likely outcome of, I recommend, well, you got to read it for yourself to see his findings. I'm in the process, halfway through an essay I'm writing on it that I'm characterizing Modern Merger Law, a return to Dante's Inferno. Because the answer is they don't have any idea. They have no idea whatsoever of what the FTC expects. They have problems with the DOJ, but they have particularly powerful problems with FTC. They can't figure out what in the world FTC is doing, why it's doing it, what criteria it is applying, and what criteria, okay? That's wrong. That's really, really bad. So why have we not seen new guidelines that reflect whatever Chair Khan wants to be the new criteria? Well, there's two plausible alternatives. One I got from my friend Adam White, who's writing a broader paper on this question, where Adam believes that several agencies in both the Biden administration and the Trump administration decided some time back that their best course of action was to maximize uncertainty. That clarity was their enemy, and so maybe the motivation is, at least in part, to maximize uncertainty, and maybe they think that's a good thing. I think as a matter of policy, it's awful, but that's plausible. The other plausible explanation is that they're aware that there have been massive changes, really important changes in administrative law, that would put in grave jeopardy immediately any new set of guidelines that they issue. When they issued the horizontal merger guidelines in 2010, the law applicable to judicial review of agency interpretative rules and policy statements was very clear. They're not reviewable. They're not reviewable because they're not legally binding. However, the Supreme Court, in two opinions, one in 2012 and one in 2016, and not divided courts, unanimous decisions, changed that completely. And made it very clear that there was a two-part test, that interpretative rules and policy statements are potentially subject to pre-application judicial review. Okay, if they pass a two-part test. Since then, every circuit, the federal circuit was the most recent, the last of them, every circuit has changed the circuit precedents. And so what we have now is a legal regime in which any interpretative rule or general statement of policy is subject to pre-application review if it passes a test that is identical to the test the Supreme Court announced as applicable to substantive rules in 1967 in its famous opinion in Abbott Laboratories. So part one is does this interpretative rule or statement of policy raise an issue that is susceptible to judicial, that a court can address without knowing the particulars of any case, okay? And then the second step is, would it require the petitioner who wants to get review right now to have to go through a lengthy and costly process in order to get to court if we were not willing to engage in pre-application, immediate pre-application review. We'd have to see the guidelines to know for sure how the first part of the test would apply. I don't have any doubt that it would pass the second part. It is just hellishly complicated and time-consuming to go through the Hart-Scott-Rodino process and then find your way into a court that would address the merits of your. So that's very easy to predict that it would be satisfied. The other is a little harder to predict and without knowing what these hypothetical guidelines would look like. But if they reflect the thinking of Chair Khan that she has expressed in speeches and articles, I don't have much doubt that they would raise issues that would be susceptible to judicial resolution prior to their application in a case. That means that you would be able, somebody would be able to go straight to court as soon as they come out and challenge them. Well, then we get two other more recent changes in administrative law. When I wrote the sixth edition of the treatise I co-author with Kristen Hickman, I characterized as rare a judicial decision that imposes a temporary injunction on an agency action. It's fair to say that I know in the seventh edition that I'm about to send off to print in the next couple of weeks, I'm going to say that practice is common. Okay, it's happening all the time, and there's two district judges who do it mostly. One is a district judge in Texas, where all the red state attorney generals run when they want to complain about something that Biden has done, and the other one is a district judge in the Ninth Circuit, where all the blue state attorneys. And the answer in almost every case is, yeah, I'm temporarily enjoying this. And then it goes to the Supreme Court, and the Supreme Court usually says nothing. It either says we're reversing this with no opinion, or it says nothing and leaves it in effect. Well, I don't like that practice at all, but that's a big part of reality today, and you can be darn sure that if and when the FTC comes out with those guidelines, somebody's going to be racing to a district court to get the temporary injunction that keeps the agencies from being able to do anything with it, in the language of the Supreme Court, until such time as the Supreme Court addresses the merits of this issue or denies a petition for writ of certiorari with respect to a circuit court opinion, which is 3 to 6 years down the road. The other thing, of course, that's new, just arrived last term, is this new, massively expanded version, much stronger version of the major questions. I don't like that either, but it's reality. And I think there's a very high likelihood that the federal district judge who would almost certainly issue the immediate temporary injunction if the FTC comes out with those guidelines would invoke the major questions doctrine. And I'm quite skeptical that a majority of Supreme Court justices would overturn that and allow the agency to implement it. My guess is it's some combination of those explanations, but the result is really something close to Dante's Inferno hell, trying to figure out what can we say to this agency? What are this agency's? What are the criteria this agency is using for decision making? How can we satisfy the agency? What kind of data should we be submitting? What kind of analysis? No one knows the answer to any of those questions. And they won't unless and until the FTC issues new guidelines.
Marina, did you want to jump in?
Sure. So first of all, it's a real pleasure to be here. I am one of the few people who believe that 6G grants authority to the Commission to issue substantive and rulemaking as well as procedural rulemaking. But Dick has made some interesting points to which I'd just like to respond a little bit first before I talk about authority. I think, Dick's experience in administrative laws, of course, unparalleled, and I completely agree with him that there has been a sea change in administrative law in this area. But what I'm less convinced about is his thinking that any new guidelines that's going to substantially strengthen merger enforcement would necessarily meet the Abbott test for immediate judicial review. So much of the merger guidelines is about methodology and metrics and the analytical framework that the agencies employ to predict which mergers are likely to reduce competition and therefore should be subject to more scrutiny. And in fact, very, very, very few mergers are ever really ever challenged, right? So it's possible to have some of the improved merger enforcement that the agency clearly want by recalibrating those tools based on new learning, based on new economic learning. And that would not, I think that would not meet the Abbott test. And if that's the path that the guidelines take, I'm not sure that the Abbott test would be met. And based on, of course, none of us know what the new guidelines will be, but based on the agency's request for information, seeking public comments, I think we can make some intelligent guesses. I think, for instance, that there'll be a new metric and not use the usual HHI to calculate market concentration for mergers for in certain difficult categories, like for the acquisition of mavericks or the acquisition of nascent competitors or in digital markets, or they might add a new framework for use in evaluating mergers in digital markets for the reason that the present framework probably does not do a very good job of considering the different features, the unique features of digital markets, like network effects and how they constitute a barrier to entry, about the aggregate, the impact of data aggregation on competition when you're talking about mergers in digital markets. So these types of adjustments, or these types of technical adjustments, may indeed bring about much more aggressive regulatory review, or at least more regulatory review. But I don't know that that raises a legal issue only that should be subject to immediate review. In fact, these are the things that we want agencies to do. We want them to periodically look at the learning, look at what is working and what is not working, and if they do their homework well and they can support the adjustments that are made, do we want the court to look at all these adjustments and to subject them to this review? I don't think so. At least I hope not. Now, if the new guidelines were to introduce novel theories of harm that are irreconcilable with traditional theories, then there would be a problem. And I think maybe that's what Dick is worried about. So if the new guidelines were to say that the agencies will base their comparative analysis on the absolute size of one or more of the emerging firms, then there'd be a problem. And I know that Chair Khan may have said something to that effect maybe at some point, maybe not in so many words. But I think whatever the personal preferences of the leadership of the agencies, they must know that a core change to Section 7 without without new legislation is just a bridge too far. And I don't think they would attempt that. So I'd say let's wait for the merger guidelines to come out and see what they do. If they can make technical adjustments and do a lot of change, I think that should pass muster. Now, going back to statutory authority, which is what I know a little bit more about than the merger guidelines and what I was just talking about. On this issue, I know that I'm a minority, and I know Maureen and I disagree with this, as does Dick and I and others. So I think that 6G does grant authority to the Commission to do competition rulemaking, not just procedural rulemaking. And why? Let me try to explain why. First of all, if you look at the language of 6G, even though it's terse, it expressly authorizes the FTC to, quote, make rules and regulations for the purposes of carrying out the provisions of the FTC Act, which would obviously include Section 5, right? Note that there's no language in the language restricting the authorization to procedural rules only. So based on textualism, it should be read to include substantive rulemaking as well. Also, there's evidence that when Congress wanted to grant an agency the power to issue only procedural rules, it knew to spell it out. So, for example, in Title VII of the Civil Rights Act, Congress authorized the EEOC to issue procedural rules only. So the fact that 6G is not so limited would support the textualist reading that Congress intended, or at least granted, whether they intended or not, they granted rulemaking authority to the Commission, both procedural and substantive. Next, National Petroleum, which a lot of people have talked about, a DC Circuit case endorsed this reading. And my reading of National Petroleum and McMoss Act that follows is a little bit different with due respect to Maureen's, okay? So National Petroleum was a case that was grounded in both UMC and UDAP principles. And the case drew no distinction between the two and simply said that 6G granted authority for rulemaking, substantive rulemaking. I know that if you look at the structural interpretation, it might be different, but structural interpretations are a bit tricky. So if you have clear statutory language, it should supersede structural interpretations. In any event, Congress essentially endorsed the reading, I think, the holding of National Petroleum with respect to competition rulemaking when it passed the McMoss Act 2 years later in '75. McMoss, as we know, heightened the procedural requirement for UDAP rulemaking, presumably to discourage its use. But it specifically said that the provision in question, Section 18, does not affect, this is the actual language, does not affect any authority of the FTC to prescribe rules with respect to unfair methods of competition. Now, since McMoss is uniformly understood to be Congress's reaction to National Petroleum, that express statement meant that National Petroleum's holding with respect to competition rulemaking remains intact because McMoss did not purport to modify it. And it's the same with the 1980 Amendments Act, which also made it a point of saying that it added more procedural protections or more enhanced the procedural requirements for UDAP rulemaking, but specifically said that was not going to affect UMC rulemaking. Now, of course, you might say, with the Supreme Court's West Virginia decision last summer, is that a game changer? To what extent would the major questions doctrine so limit the content of any rule that could nothing would survive a major questions challenge at all, right? So you couldn't really have any rule because of the major questions doctrine. Of course, we don't know. It's too early in the history for us to know exactly how courts would define the major questions doctrine, as a couple of people have already pointed out. So I guess the question is, would it, for instance, allow for rulemaking on non-competes at all, right? My own thinking is that I actually think that the non-compete area occupy a very promising area for the FTC's first foray into rulemaking. And I think this because the adverse effects of non-compete agreements on the labor market and even on the product market are pretty well documented. Well, on the labor market, it's very well documented. On the product market, maybe it's not as well documented. But there's no question that these non-competes interferes with competition in the labor market, right? So, and the FTC has used this policy-making tools quite well, I thought, to collect the data to show that. It has canvassed the academic literature, and it has held workshops and consulted experts. And people say, well, but the FTC has never done, or the Antitrust Division has never done one of these cases until very recently. Well, but it is a restraint of trade, right? It is a vertical restraint. Non-competes are definitely contracts in restraint of trade, and so are properly subject to the antitrust law. And the theory of the case against them is not novel at all. Now, having said that, I should say that having said that non-compete is a good candidate for rulemaking, I can't say I'm optimistic that the current proposed rule, if the final rule were to adhere to that version, I don't think it's going to have a very good chance of overcoming the major questions doctrine. And that's because non-competes are vertical restraints, and vertical restraints have traditionally not been subject to the per se rule. And also, common law has always recognized at least a couple of legitimate business justifications for non-competes, right? The trade secrets and also training to incentivize employers to give training. So given that, a per se ban covering all non-competes across the board, with just one exception for non-competes associated with the sale of a business, would probably involve a major policy question, however you define a major policy question, at least I think so, in which case it would require clear congressional authority. And I don't think the authority found in 6G or in other provisions of the FTC Act would grant that clear congressional authority. But if the final rule follows one of the alternatives raised in the NPRN, which are the presumptions, right? I don't think it would trigger the major questions doctrine, because non-compete agreements, by their express terms, restrain competition. So they fall under the antitrust law. And given what we know about their use, and there's a lot of documentation about that, I think there should be much more enforcement against them. And the problem is, and I think the reason that there hasn't been much enforcement against them, is the current sad state of the rule of reason, which makes it very, very difficult for the rule of reason to be applied successfully in any case where the rule of reason applies. And this is where rulemaking can be put to good use in making the rule of reason administrable, to operationalize the rule of reason, if you will, because a rule doesn't have to be a per se rule. It doesn't have to establish bright-line tests. It can establish presumptions. So think about what antitrust is about and why we have this problem, right? Because antitrust focuses on effects. So in a rule of reason case, you have to show that the bad conduct causes effects, adverse effects on competition, which entails a very detailed market analysis, which involves showing that the defendant has market power in the relevant market, which is all very difficult, right? But the FTC can and has accumulated evidence of effects, right? It's accumulated quite a bit of literature and evidence on effects. So now this documentation can be used to support a rule that presumes effects, which would make the rule of reason administrable, which would not plow over the rule of reason, but just operationalize it. So for instance, the rule could perhaps have two tiers. I'm not saying how the rule be, but you could have a two-tier, for instance, and you could conclusively presume anti-competitive effects when it is applied, when it is demanded of low wages workers, right? Which is essentially applying per se rule for those workers. But for other groups of workers, the rule's presumption can be rebuttable, in which case the employer will be able to rebut it if it can by showing that it's needed in order to protect its trade secrets and that there's no other less restrictive alternative than the non-compete, or can say that it provides training, expensive training to employees, that it's free-rideable, and therefore you need a non-compete in order to incentivize employers to provide this type of training. So if the final rule, I think, if it takes this form, it wouldn't be seen as plowing over the rule of reason. It would just be making this crazy rule that's not workable a little bit more workable, so that plaintiffs would not always lose in rule of reason cases. So if that's the case, I think it might be okay. I don't think it's controversial. I know it sounds strange for me to be saying that's not controversial when so many people are berating the FTC over this proposed rule on non-competes. But I think part of the criticism, or much of the criticism, is because of the sheer breadth of the rule. And they're thinking that, wow, all of a sudden you're just saying everything is going to be per se unlawful. If you take away that factor, I don't see it as that controversial. I mean, how many people, be they conservative or Republican, would be able to say that, would find it objectionable that we ban non-competes for someone flipping burgers or making sandwiches at a fast food restaurant, right? Or would say that, well, even for most cases, we can presume this anti-competitive because, well, how many workers really are in a position to know trade secrets and so forth? And we'll put the burden on the employer because the employer is the one who has that kind of information to rebut the presumption, right? So I don't think it's that controversial. Also, I don't think it is controversial in the same. Now, I will preface it by saying that I agreed with the dissent in the three major questions doctrine cases in the 2021 term. But even though I agree with the dissent, I can see how it is possible to say that they have major questions and that they are controversial because we're talking about climate change, we're talking about a vaccine mandate, and we're talking about eviction moratoriums, right? So especially in our crazy times where everything is so polarizing, it's easy to see how that can be considered politically controversial. But non-competes, I don't think it's that controversial. Maybe it's me. But, well, in any event, I think I'll just close by saying that I would like to see a non-compete rule go through. And I think, though, that this is going to be a test case. It is a test case, and so I think it might be better for the Commission to be a little bit more modest, because if you are perceived as overreaching, what I worry is that not only would the Supreme Court shut down that rule, but it may then also say that 6B does not authorize substantive competition rulemaking at all.
Oh, thank you, Marina. So, Nikhil, by being the last in the panel, you get to adjudicate over all the views that have been presented so far.
I would not only not presume to adjudicate over the views of the brain trust on this panel and our previous panel, but I won't even presume to engage on necessarily the same topic. So I think we've heard a lot about the questions of legal authorization for both UMC, the issues around UDAP and MAGMOS rulemaking, and some of the issues there around whether these processes have really been streamlined or something else. I thought maybe I might offer a couple of thoughts. These come in large part from comments that we've already offered in one of the rulemaking procedures, but really around the process. And I think Commissioner Wilson very astutely recommended the great paper by Tim Meares and Howard Beals on rulemaking in the past, which I found very informative. I think one of the lessons that really comes out of that is the importance of the process and the importance of the fact-finding process being sort of unbiased, really engaging in understanding the potential harms that might be identified and might be driving the idea for a rule, but also equally engaging in an honest way with the evidentiary record that might support pro-competitive benefits for consumers, and make sure that that conduct is also examined closely and incorporated into any process for rulemaking. So really, I think the so-called sort of commercial surveillance rulemaking, and I'll use that term in scare quotes, I hope they came across, is a good example of where I think this kind of exploration is really needed. And I think, and I hope that the agency will really ask the question in an honest way of whether the record supports the existence, magnitude, and mechanism of the harms that are alleged in the ANPRM, and make sure that the process that they undertake really explores all the potential benefits of that conduct as well, both to consumers and to competition more broadly. Drawing on, as we've talked about today, and as we've heard about enforcement experience, existing research in this area, including a wide body of research from the IO literature and other marketing literature, as well as new data, the potential for studies, as both Commissioner Wilson and Maureen mentioned with the 6B powers, is potentially a very a good area for further exploration there. So this was really the focus of our comment in this data security rulemaking ANPRM. Again, we know it's early, and this is a first sort of salvo here on what a potential rule might look like. There's no rule actually proposed in the document. But I do think that the language in the ANPRM, it does, I think, express some skepticism on a number of fronts that really only flow in one direction. So I think if you read this document, the harms are sort of presumed. They are accepted as concrete, as real, as very clear and without doubt. And any potential benefits are described as as theoretical or at most limited in scope, without really any evidence of the record and without really engaging in the pre-existing research in this front. It goes so far as to ask for help on legal theories that would support or justify barring certain practices. And even I think the label of describing this as commercial surveillance is skewed and loaded language, and it's clearly going for a certain effect and trying to produce a certain emotional reaction that I think is not consistent with an honest exploration of the pro-competitive benefits versus the potential for anti-competitive harms. So again, we encourage the agency to fully consider the wealth of evidence that personalization in the digital context, both in terms of ads and other types of content, provides massive benefits to consumers, small businesses, and the economy as a whole. That should, of course, be balanced against any research or exploration of potential harms. And that is entirely appropriate and the process within rulemaking. So as I mentioned, there is a substantial body of research on the benefits of truthful advertising, on the ability to reduce search costs, how that happens on digital platforms and online services. That is in large part completely unmentioned in the ANPRM, but I think that does need to be considered in the next phase of the process going on here. There's work that the FTC itself has undertaken in this context from BE and other areas, which again I think should sort of be incorporated in any potential ultimate rule that gets proposed, as well as further steps in the UDAP rulemaking process. I think there's also various steps that are underway in the industry right now to balance providing advertisers and other market participants with this valuable ability to reach and grow their businesses, but also in ways that protect user data. So there's a lot of work being done on what are called privacy-enhancing technologies, or PETs. That's an area that's really ripe for understanding in any kind of rulemaking that seeks to focus on data security and advertising and the use of data. And it's an important area that should be understood in any rulemaking that engages in this step. I think it is important to also mention part of the process is, to go back to some of the comments on the previous panel about the MAGMOS process and the steps that were taken to either, depending on your point of view, streamline this process or not. I do think if you read the commercial surveillance ANPRM, at its limits, it looks like a very, very extensive legislative change to fundamental sort of digital business practices writ large. And if you look at other places outside of the U.S. where these types of measures have been taken, they have been the result of massive legislative efforts. So if you look at the GDPR or the Digital Markets Act in Europe, these were multi-year processes engaging multiple different bodies of government. So in Europe, the European Commission, the European Parliament, the European Council in the trilogue process, again, spanned 18 months to 24 months, multiple opportunities for comment, multiple reports that were produced in that process, both by the bodies themselves as well as by third-party research that was commissioned in that process. If you look at a place like Australia, there's a 5-year process going on to figure out whether there should be even changes recommended to the Treasury and the Parliament on changes that might touch on sort of similar areas. The digital platform services inquiry that's going on, not scheduled to complete for another couple of years. So I think in that context, when you realize sort of how, when you're talking about making changes to such a fundamental part of the economy and such a fundamental part of digital platforms, and we see internationally the kinds of processes that are going into making some of these kinds of changes, having a staff report that is public for comment does not seem insane to me in that context. Maybe one other thing I might say, and specifically on the issue of non-competes, where we've not been as engaged, frankly, and I have not been sort of as deep on this. So I apologize to my fellow panelists who are much deeper on this. But it did strike me, one area that struck me, and that was this idea, and we've heard it referenced a couple of times today, about this carve-out in this broad barring of non-competes for this idea that you can sell a business, and maybe that might trigger a non-compete that might be acceptable, with this idea that you need to own 25% or more of the business in order to do it. This is another area where I think it would behoove the agency to understand the dynamics of a number of different industries, including ones that are characterized by high levels of investment, including VC investment or private equity investment, where frankly there are no companies where you have people that own 25% or more of a business, or almost none. I took a recent example. This merger is obviously still under review, but if you look at Adobe's proposed acquisition of Figma, it's two founders of Figma. If that deal goes through, they will each make, according to public reports, $2 billion apiece. But according to this rule, a non-compete would be, coercive or exploitative of them, because they would not trigger the ability to be exempt from the non-compete rule based on an ownership stake. That to me suggests that that's not the right sort of standard, and there should be a deeper understanding of what are the dynamics, especially in a place where you're talking about M&A and you're talking about some really dynamic issues around ex-ante incentives for investment and M&A in the first place. Impacting that, I think, also has potential for major impacts. Maybe not in the MQD context, but major in the general use of the word, impacts on, again, investment, startup formation, VC funding, et cetera. So I think I might end there, and if you want to have time for questions, I'm happy to do that.
Thank you, Nikhil. Thank you, everyone. So I'm going to fight my personal instinct to ask everybody a bunch of M&A questions, because that's near and dear to my heart, and open it up to the floor. If anybody has any questions for our panelists, we've got about 5 minutes to go. Anyone?
No.
Oh, yeah. And then Blake. We'll go. Rajdeep, do you want to lead? And then Blake?
So my question is for Nikhil. Obviously met you, and you mentioned that, so specifically with I'll add this careful as well, the consuming surveillance rule, that the industry is moving on this matter, just as the FTC is moving on this matter. How do you see the dynamics of the FTC taking more resources and applying here the industry, while the industry is ultimately itself separately? How do you see the dynamic of the FTC has to act somewhat quickly if the industry is taking input, but the time to make this rule how do you see the partnership with the industry and the FTC working on that?
Yeah. Do you want to repeat the question?
Yeah, so I think the question just briefly is, what's that interaction between industry and the FTC? And then if the regulatory process is just slower, how does that dynamic play out in practice?
Yeah, I think it's a good question. I think this is actually what is inherent in the idea of Magmoss rulemaking, and why these procedures were put into place in the first instance was to make sure there was a good understanding of the various different views in the market from the stakeholders involved. And so I do think that's why it's important that there is a rich and robust process of understanding what is actually happening in the industry. The example I used was around sort of changes around use of data. That is both in response to other regulatory trends, international regulatory trends, but also just technological advancement, right? There's an ability today to do a lot more with a lot less data, or data that's been cleaned in certain ways, or personal identifying information has been removed, but you can still use that data to, for example, train large language models or machine learning models that optimize the delivery of advertising in ways that were not possible, say, 10 years ago, or even 5 years ago, especially when you sort of take into account the pricing of compute and those resources. So I think the broader point is just, it's not enough to just focus on the idea that there is some harm that the agency believes is out there. There also needs to be engagement with the idea that One, there are benefits that come from this conduct. And to go back to a little bit to the rule of reason, right, the entire idea there is to balance one against the other, to think about not just one side of the equation, but the other as well. And I think the additional point about understanding where technology is going is very important in order to actually have a rule that will survive. Right? So yes, it's important potentially to move quickly, but it's also important to have a rule that actually is resilient in the face of technological innovation so that you don't look back in 5 years and say, this just doesn't make sense anymore. Hopefully we wouldn't be in that position. And that's why I think it is important to take that time to understand both the current and the future technological landscape.
Why don't we do one more and then we'll break.
Yeah, thanks. So I had a question about this whole issue of non-legislative rules that Professor Pierce and Professor Lau were raising, because it strikes me that that has some implications for this non-compete rule on judicial review. So let's say that the Supreme Court, in my view, erroneously concludes that FTC lacks authority to issue this rule, and a substantive rule. But if FTC has the authority to interpret rules or statements of policy anyway, is the remedy just to say, well, this is a non-binding rule? Because they haven't violated, if that's true, they've just issued a non-binding guidance document fully in compliance with the APA and all other relevant statutes, and it ought to remain in effect.
They've never done that. The courts have never done that. They don't. They're not that forgiving. I mean, if you say you're doing a substantive rulemaking and then you issue a rule that says it's a substantive rule, and you flunk some of you flunked, you're gone, that's it. The courts never say, oh, but it's fine, we're going to convert it into an that never happens. If you're going to issue an interpretative rule or a general statement of policy, that's what you say. If you if you're going to issue a substantive rule, that's what you say. And if you issue a substantive rule and you don't have the power to issue a substantive rule, what you have is an invalid substantive rule. And the agency can then say, now that we know we don't have that power, we're going to issue a policy statement that sounds a lot like the substantive rule we didn't have the power. But no court's just going to...
the next day, they just issue a rule, an interpretive rule.
That's under a new administration, remember. All of this stuff, the temporal dimension that somebody recently pointed out, it is critically important for many, many reasons. One is whatever Chair Khan does, her successor is unlikely to share her values and her preferences. That would be exceedingly rare, particularly in these days of political polarity. So basically, as a practical matter, you better figure out how to do something right now and not something that you might be able to convert into a valid action 3, 4, 5, 6 years later after the courts tell you that your first attempt was invalid because you don't have that power.
Well, I'll say I'm slightly more optimistic. I think if let's say a non-compete in the form of the NPRN version goes up to the court and the court shuts it down, right? Then I think the FTC can draft guidelines, right? Which will be more like what I was suggesting, where you use presumptions and so forth, and you flesh it out, and it's supported by studies. I think it can pass. I think it can pass muster.
Why couldn't you do it simultaneously?
Probably.
One legislative rule,
Probably not. Probably not. Which leads me to wonder whether the FTC strategically would have been better off issuing guidelines first, and then according to the guidelines bring a lot of enforcement actions, doing the low-hanging fruit first, and then go for rulemaking, and that might be better. I don't know.
In the interest of time, I just want to make sure Maureen's got an opportunity to weigh in.
Yeah, thank you. Going to Dick's point about the next administration and the next, one of the benefits of the FTC's structure of having a multi-member bipartisan commission was to allow, and to move in a bipartisan way, was to allow continuity across administrations. So you've actually seen for a lot of the FTC's enforcement and a lot of the things like the horizontal merger guidelines, continuity, not big swings back and forth. And so as we're moving away and saying, well, we don't need bipartisan support, or we don't, we're not concerned about, kind of building on the learning of the previous version of the horizontal merger guidelines, we lose that, right? And so we may end up with a lot of the sharp swings back and forth that having a more consensus view actually helped moderate. And so I think that's something that's being a little bit lost currently by these very sharp changes.
Just one comment on this, and I may not understand the nuance of what you're asking, and it's been a long time since I took admin law, but it seems to me the big difference would be just in actual enforcement. That if you actually had a law that had, or a rule that was a substantive rule that was upheld, you would actually be able to enforce on the terms of that rule, whereas if you had a policy statement or a conversion into a policy statement, you'll remind me what the level of deference is, but it's not binding law, right? So if as a litigant on the other side of that, you would say, okay, yeah, there's a policy statement, but now I'm going to put forward all my evidence on why this was a pro-competitive non-compete and why it had zero impact on the market, which I wouldn't have been able to do if I was under a substantive rule.
Let me just make one follow-up point to what Maureen said. And I think Maureen really makes a very good point, because we've had really a lot of successes. I'm thinking of the pay for delay
Pay for
agenda,
delay is
right? I think
excellent
I think it was Bob Potofsky who started it, and then Tim Mears continued with it, was followed by Majoris, and then Bill Kovacic, and another
Kovacic, and then it was Leibowitz.
Leibowitz, and then Ramirez, and of course you're a strong supporter of the agenda, and then the hospital mergers area, right? There's been so much. It would be nice if we could find those areas of consensus and continue.
Yes, I agree. I think the FTC has, really moved antitrust law forward in ways that benefit not just the FTC's ability to enforce, but all antitrust enforcers by sticking to a more of a case-by-case enforcement under traditional antitrust standards, and it has garnered a lot of bipartisan support across administrations.
Well, thank you, everyone. We should continue this just simply over lunch, since there's a lot of thoughts. And Aaron, could you just remind me when we're going to reconvene for Elizabeth's comments?
At 1 o'clock.
1 o'clock. So lunch is just outside. We'll come back here for 1 o'clock, for our 1 o'clock keynote. And just join me in thanking our panelists.